because this will be an exciting panel. Not so much because the title, insolvency, bankruptcy, may wake you up, but the speakers and what they will have to tell you and which the information and analysis they are going to share with you will certainly excite you. And to begin with, without further ado, I'm not going yet to introduce the first speaker, but try to place and the relevance of the subject a bit in importance. I have calculated, thanks to information that we had on the internet, that there have been in the past 50, 60 years of civil aviation in Europe about 1,000 bankrupt airlines. 1,000 airlines have reached the bankruptcy state, insolvency. And some of them are very well known. We know, of course, the well-respected Belgium carrier, which was created in 1923 and went bankrupt in 2001. And I also noted that many of those airlines survive for 2, 3, 6 years, a limited period of time, and then bankruptcy enters into the life of those airlines. And that is, of course, quite a horrible scenario, because a lot of investors behind the aircraft, human resources which have to be coped with, and passengers. All of these aspects, ladies and gentlemen, will be discussed this afternoon. And I have tried to structure it in a more or less logical way. That's the first phase. After the bankruptcy, we have the investors who have to see what they can do with the aircraft, whether they can get it back, the financial transactions, which will be addressed by my colleague and friend on the left side, Mark Bisset, who is a partner in Clyde Co in London and who studied in Oxford and who has a lot of cases going on in Russia, which accounts for 125 of those 1,000 bankruptcies. So I believe that Mark is speaking from a wonderful and broad experience, and I'm very happy that he is prepared to share that with us, and I will see to it that I will create a picture, a colorful session this afternoon. To begin with, Mark Bisset from London, and Mark, the floor is yours.
Thanks very much, Pablo. I'm more than happy to speak today. It's a real privilege, and I'd just like to add Clyde Co's thanks to Lewis Business School and to Laura for organising such a fantastic event. Up, down, there we go. Advantage of being tall. As Pablo says, I'm going to focus today on what happens to an airline's aircraft, an airline's financed and leased aircraft, when the airline unfortunately goes into insolvency. As I'm sure we're well aware, most airlines do not own their own aircraft. Most airlines' aircraft are financed or leased by investors who, let's face it, don't take particularly well to having to have their aircraft with an insolvent airline. Conversely, from the airline's perspective, obviously the ability to carry on business, notwithstanding the insolvency, is dependent upon the availability of those aircraft. So there's a balancing act in the law, in international legislation, between the interests of the investors and the interests of the airline in trying to get out of financial difficulties and carry on as a going concern. Each country in the world basically has its own insolvency regimes, and what I'll be looking at here is the attempt to harmonise those regimes via the Cape Town Convention. Fundamentally, though, each country's insolvency regime basically breaks down into sort of two main categories, either liquidation or administration. Certainly that's the case in the UK. Liquidation, as the name suggests, is that the airline just basically goes bust and all bets are off and all the assets get sold for the best price available. Administration, probably the regime that most airlines will tend to go into if they're in financial difficulties. And the idea behind an administration, certainly again in the UK, is that the insolvency administrator has to try and get that airline out of those troubles, cure problems, and make sure that the airline carries on as a going concern for the benefit of employees, etc., passengers, etc. And certainly look later in this session on how passenger rights are protected in that sort of circumstance. But as I say, part of the problem is investors may take a fundamentally different view, and investors may fundamentally just want their aircraft back and be able to sell their aircraft to somebody else, lease it to somebody else. So, what's happened in the last 20 years has been an attempt, primarily by Unit Dwyer and the Aviation Working Group, to harmonise insolvency regimes in the aviation context across the world. And the result of this is basically the Cape Town Convention on International Interests in Mobile Equipment. But those of you who aren't familiar with it, I'll spend a couple of slides explaining the background, other things that it does other than just dealing with insolvency, etc. The convention was signed in 2001. It came into force in April 2004, signed by 59 states. But in the aviation context, the convention also has a satellite element and a rail element. But in the aviation context, via legislation called the Aircraft Protocol, the convention came into force in the aviation world in March 2006, and there were 46 ratifications in the aviation world. What we're really driving at in the convention, really trying to deal with, is the quite astronomical cost of financing aircraft. Over the next 10 years, the financing cost for airlines is $125 billion dollars per annum, which by any standard is an astonishing amount of money. And fundamentally, investors are not going to be willing to put that sort of amount of money into the airline business without certain protections. Conversely, if those investors have those protections, then airlines can find themselves having cheaper financing available to them. Basically, the idea of the Cape Town Convention is to increase the protection of the investors in a way that allows cheaper financing for the airlines. IATA estimated that the Cape Town Convention by itself, in terms of financing costs, would save $5 billion, which, okay, fair enough, sorry, $5 million per annum, which, okay, fair enough, isn't massive in the context of $125 billion, but is a start. But when everything started on the Cape Town Convention, when work started on the Cape Town Convention, INSEAD and NYU did a report which identified the basics that need to be addressed in order to give investors the protections that I've been mentioning. And they came up with these 3 principles, which I think are quite interesting, because they explain a lot of the context. Transparency priority principle, the prompt enforcement principle, and what we'll really be looking at, which is the bankruptcy law enforcement principle. And so what they're basically saying is, if an investor has a mortgage over an aircraft or is leasing an aircraft, it needs to know, firstly, that interest overrides other people's interest, so transparent priority. Second, that interest can be enforced swiftly, so prompt enforcement. And thirdly, that interest is effective in the bankruptcy or the insolvency of the airline, which is what we'll be looking at in a few slides. As much as say that, okay, so 46 states have ratified the Cape Town Convention. It's definitely worth noting that some of the most significant states in international aviation have ratified it. So the BRIC countries, Brazil, Russia, India, China, the United States, and the UAE. In the European Union, Ireland, Luxembourg, the Netherlands, Latvia, and Malta. I'll come on, there's a reason why there's fairly patchy coverage in the EU, and I'll come on to that in a minute. So the convention created, again, sort of by way of background to what we were talking about on insolvency, the convention created new interests in aircraft. So, and these are called international interests. And it created a new register, an online register of those interests. So if you're a mortgagee taking a mortgage over an aircraft or you're leasing an aircraft, that mortgage or leased interest will be an international interest, and you can go and register it on the international registry, which is run out of Dublin. So as I say, the 3 types of international interest, the main ones we deal with are basically mortgages and leasing interests. There's also title reservation interests. And I also sort of mentioned on the slide a useful thing, which is you can register sales on the international register, but that's not really relevant to today. There needs to be a connecting factor. So the connecting factor which makes the convention relevant is if your aircraft is either registered in a contracting state, or the debtor, i.e. the mortgagor or the lessee, is registered and is located in a contracting state. So at the moment that creates anomalies. So, for example, a lot of Italian aircraft are leased from, are basically registered in Ireland and then leased from Irish lessors. You know, so if you go to Fiumicino, you see a lot of EI registration marks on what would ostensibly be Italian aircraft. Those aircraft, so in respect to those aircraft, Ireland is a contracting state and Italy is not. So, so we're in a situation at the moment where there's sort of patchwork coverage and there's anomalies that come out of that, which I'll come on to when we talk briefly about enforcement. Same with Russia. Actually, Russia's the reverse situation. So for Russia, a lot of aircraft are registered in Bermuda under an 83 bis arrangement. So Bermuda is not a Cape Town contracting state, and Russia is. So that's the reverse of the Ireland-Italy situation. In terms of insolvency, then, Article 11 of the Cape Town Convention deals with insolvency, and basically, generalizing fairly crassly, but the intention behind Article 11 is to try and ensure that there's a harmonized insolvency regime across the world, which looks very similar to Section 1110 of the US Bankruptcy Code. I'll come on to that on the next slide. But what the convention says is that each contracting state can choose one of three bankruptcy regimes to apply. And these are called, very imaginatively, Alternative A, Alternative B, and the third option is to basically have neither of those. They're not really much of an option. Alternative A is called the hard regime, and Alternative B is called the soft regime, and I'll explain why that is in a second. But those who are trying to get the convention ratified across the world will basically say that Alternative A is the choice that most contracting states should make. And which is on the next slide. Sorry, I mentioned this point now. The EU has ratified the Cape Town Convention, but it needs to be ratified by each individual member state. As I've said, only 5 EU member states have so far ratified the convention. None of those have made a choice on insolvency because of a technicality in EU law where they're not allowed to. But going forwards, EU member states which will be ratifying the Cape Town Convention in the next few years will be basically choosing either Alternative A, Alternative B, or making no choice at all. In the UK, we've had a very lengthy economic assessment as to whether the Cape Town Convention is of any use or benefit or economic value at all. The upshot of which was that every single person that responded on that assessment, except one entity, which I won't name, said that it is of benefit. So the UK will probably ratify the convention next year and probably choose Alternative A. There's a bit of an annoying technicality in that the EU, so the UK can't make a declaration declaring that Alternative A is relevant. We have to amend our existing law, and that takes longer, which is a bit of a pain, but that's just the way it is. So Alternative A. So as I said, there have been 46 states that have ratified the Cape Town Convention. Of those states, about 70% have chosen Alternative A. The others have chosen nothing, except for one state, Mexico, which has chosen Alternative B, and thereby got itself into a lot of trouble, which I won't dwell on. But Alternative A says, and this is why it's called the hard regime, and just sort of sidestepping slightly, in the UK at the moment, if an airline goes into administration, it's basically up to the courts to decide what happens with that airline's assets. So the insolvency administrator and the court and creditors will get together, and this is generalizing, but get together and decide whether to hand some aircraft back, whether to try and continue paying rent for some aircraft or mortgage payment or loan payments and keep those aircraft running, etc., etc. There's a discussion and it takes time. And as I said, the whole point is to try and make sure that the airline can come out of that administration as a going concern, albeit maybe with fewer aircraft or fewer routes or whatever. But that's the intention. Alternative A is called the hard regime because it's basically saying, very similar to, as I say, to Chapter 11 of the US Bankruptcy Code, either give the aircraft back or tell me that you're going, or cure all existing defaults and tell me that you're going to cure all the future defaults. So the convention's provided what's called a waiting period. And as I say on the slide, the insolvency administrator at the end of that waiting period must either give the aircraft back or cure defaults and agree to perform for future obligations. The convention doesn't stipulate a waiting period in itself, but most states have chosen what's recommended by the Aviation Working Group, which is 60 days. Some have chosen something different, so India's chosen 2 months, for example, but the recommended period is 60 days. And dare one say that 60 days is not a huge amount of time for an insolvency administrator to decide whether it's going to cure defaults and continue performing obligations in respect of an aircraft. 60 days, currently under the UK system, is far too fast for the courts, etc., to decide what to do. So dare one say, in most circumstances, it's probably likely that once the 60-day period is up, most lessors, mortgagees would be entitled on that the insolvency administrator give the aircraft back. Obviously, it has implications on the airline continuing as a going concern, serving passengers, albeit that it's in financial difficulties, etc. As I mentioned, Alternative B has only been ratified by Mexico, and there have been some enforcement actions recently in Mexico, which were not particularly successful, but most people in the market will say the reason they were not successful is because Mexico chose Alternative B. Cape Town Convention also sets out default remedies. So if it comes to the point where the lessor is entitled to its aircraft back, or the mortgagee is entitled to call under the loan and get its aircraft back under its mortgage, the convention itself sets out the remedies. And I think it's probably fair to say that most of these are fairly standard remedies that you'll find in most jurisdictions across the world, except for the timing, which is pretty swift. So, most existing countries would say that if an airline defaults under a mortgage arrangement or a lease, the lessor or the mortgagee can take possession of the aircraft and sell it, and that's fairly standard. Most jurisdictions will provide some sort of interim relief, so you can go to the court and have the aircraft arrested and grounded or whatever. And again, in most countries, that's fairly standard. Where the convention sort of adds its own little twist is that states can declare within how many days that relief must be provided. And I don't think many have, but because it depends on the circumstances really. But certainly in the UK, even without the convention, you can go to the court and have an aircraft arrested literally overnight. So that interim relief tends not to be such an issue in most jurisdictions. And there's an article on exclusion or otherwise of self-help remedies. Self-help is where a lessor or mortgagee can basically come and get its aircraft back without going to the courts. That's a possibility that's available in England. Not that people wouldn't always necessarily want to use that route, but it is a possibility. Russia, rather strangely, decided that it would adopt the self-help remedy. So strictly speaking, a lessor or mortgagee can now go to Russia and not bother to go through the courts and attempt to seize and export an aircraft. But quite frankly, who would want to do that? Obviously, you'd want to go through the courts for various protections that any sensible person would seek to use. And just to mention that the Cape Town Convention also created this item called a deregistration and export request authorization. So it's called abbreviated as an IDERA. This is a document from the airline to the lessor or the mortgagee that it can use to go to the state of registry and get an aircraft deregistered from that registry and exported. Because obviously one of the main difficulties in repossessing aircraft is it can be relatively straightforward to go and seize the aircraft itself, or its technical records, or both. But it's sometimes quite hard to then go to the registry and get the registry to agree to deregister that aircraft and sell it. And certainly in Russia, it's quite hard to actually get an aircraft exported. A lot of aircraft are in Russia under a regime which means that they may not necessarily have paid all customs duties applicable when the aircraft was imported. And the customs authorities are quite clever at seeing that when you try and export an aircraft, and will tend to demand that lessors, etc., pay up unpaid customs duties before the aircraft's exported. But anyway, in theory, the IDERA should help with that. And then the convention has stipulated a period within that which the state registry must assist and must do that, which is 5 working days. And I say that in a sort of English cynical way without laughing, because quite frankly, there's no chance that a lessor or mortgagee would go to the Russian state registry and say, hello, here's my idea, please. I'd like to export that aircraft, please. And the Russian says, oh, that's fine, sir. You know, I'll put a calendar note in my diary to make sure the aircraft's out of the country in 5 working days. That, to be honest, is not going to happen. But, you know, that's what the Commission says. So if nothing else, it gives you a sort of stick to wave at, e.g. the Russians, should you be so stupid as to try and wave a stick at Russians. And to be honest, that's about it. That's us. That's to remind us that this is a glamorous industry, notwithstanding that we're talking about depressing things like insolvency. Thanks.
Thank you very much, Mark, for setting up this very helpful legal platform for picturing, for contextualizing aircraft as very valuable assets. And that means that a variety of interests, as you have, I believe, very precisely explained, are linked to their operation. And they are also moving objects, which creates problems of choice of law. Cape Town Convention tries to remedy some of those choices, but of course many of them are still governed by national law, as explained by you. With that, I would like to thank you on behalf of the audience for this information.